I just want to see if I'll be able to dismissal counsel. I've been incarcerated going on 3 years, and I still to seeing yet the discovery pack. Any racing.
How are you being rushed? You're going to
Exactly.
jury trial on February 6th.
I'm barely hearing anything about it just within these past couple months, man.
Oh, no, this is going.
Well, I think they've got a legitimate argument. And I hate to say that, but I think it's a fair argument.
For continuance is based upon a phone call that he made last night. This trial is going. Legal thoughts on certain situations.
Judge, I started out a long time ago thinking I knew everything about the law. I'm not asking, I've been a trial lawyer 24 years, which I believe is a little less than you, but I'm not asking.
He entered a plea. Judge Boyd dropped a harsh sentence. 4 separate 20-year prison terms for aggravated robbery, all handed down on the same day.
San Antonio police are investigating 2 robberies this morning and trying to figure out if they are connected. The first one happened in the 3100 block of Blanco Road. That's near Fresno Road on the north side. Police say 2 men walked into the J&A grocery store and robbed the clerk at gunpoint. The 2 men then got in a blue pickup truck and drove off. Police say this robbery happened around 11:30 last night. Police say the second robbery happened about 15 minutes later at another convenience store about 5 minutes away. They say the 2 men walked into that store at the Citgo gas station on Gardena near Vance Jackson. Police say the 2 men also pulled out guns and pointed them at the clerk. They say the gunman also fired 3 shots into the wall before running off. Police say they are not sure if the 2 are connected, but they are looking into it because the 2 robberies happened so close to one another.
Judge, Mr. Estrada was kind enough to let me know that somehow they said he was exposed to COVID, so I got him a mask. That's why he's wearing a mask. I don't know if it's true or not, but anyway, that's why.
All right, so we were scheduled for jury trial. Where are we?
Judge, you made an offer. I've thoroughly discussed the offer with Mr. Estrada. I've explained the consequences of not taking the offer and that the court will not take any agreement. It will just be an open plea in court. I passed on the offer, and I'll be real blunt. I've given him ojos that if he gets a lot higher, it's on him, not me, and I'm not going to feel guilty. He said that he wants a trial, so I'm passing it on to the court to get it.
All right, Ms. Ferguson, I need a jury trial date for this. As criminal trial division, I need it as early as possible. All right, you're coming back for jury trial on February 6th. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you'll need to plead open to the court. You'll be brought over dressed for trial in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to speak to your attorney and do a clothing exchange. If there's an issue with the clothing exchange, let the court know.
Judge, I appreciate it. Thank you for letting me come in today rather than Tuesday. And I'm still going to bet with you on the fact that they're going to cancel court.
You think they're going to cancel the court on that date?
It's not that I would, but I've just, you notice certain things like the sun rising in the east and setting in the west. After a while, you notice patterns.
May I say something, Mom?
Sure.
I just want to see if I'll be able to dismissal counsel. I've been incarcerated going on 3 years, and I still to seeing yet the discovery pack. Any racing arrest.
Oh, you want to see the evidence? State. Can we put him in the box? Counsel, can you let him see the evidence? And if you want another attorney for your jury trial, they need to be ready for trial on February 6th. You understand?
No.
And Judge, just be clear, I don't care one way or another, but if you are going to put someone else on the case, please let me know so I won't.
Oh, no, he's going to have if he wants another attorney, you'll have to hire that attorney. And that attorney needs to be excused. That attorney needs to be ready for jury trial on February 6th. And state, if you'll let him, and counsel, if you'll stay so he can see the state trial.
Sure. Other case, Mr. Estrada, he really, really doesn't like me, which is why I didn't do the discovery, told me to stop. I'm just telling you because I don't want to surprise you. I'm going to file motions to withdraw to protect myself.
Oh, I understand.
Okay.
Where is he? If you can come forward, sir.
And Robert Maurer threw his son under the bus and said that I asked him to take the case and he said no, but my son will.
Nobody can do as good as Eddie Judge. He's the best judge I've ever seen. That's what I've ever seen.
His vision is
I would
also,
want him as my lawyer if I were.
he has cataracts, so let's not.
All right, so I want to let you know something. You came before the court and you said that you had not seen the state's file. I'm being told that you no longer want to see the state's file. So let me just tell you what's going to end up happening. You're going to go to trial, whether you've seen the evidence or not. That's completely up to you. The court gave you the opportunity to sit in court and look at the state's file. You're choosing not to. So you're going to come back for trial on that day. Do you understand?
It's not that I don't want to see it, Your Honor, it's just, I've been incarcerated going on 3 years and I just feel like I'm being rushed into something that.
Oh, no, you said you've been incarcerated for 3 years. So
Yes,
how
I
are you
have.
being rushed? You're going to
Exactly.
jury trial on February
And
6th.
I'm barely hearing anything about it just within these past couple months, man.
He was
No.
in another county, Judge.
I've been in another county, so this whole time I've been incarcerated, I haven't heard anything out of Bear
So
County.
let me ask you this. I want you to internalize what I'm saying. You were in custody in another county for what reason?
For ag robbery, allegedly.
So there you go. So this case is going to trial on February 6th. If you would like, I've given you the opportunity to sit in the box and read what the state has. What the state has in their file is what they have. The only,
I understand that, Your Honor.
here's the thing, the only thing about it, what's in the state's file are the names and police reports. Those people are not going to come in and let you talk to them right now because
No,
that's
I-
not
I
what it is.
understand. I understand what you're
but
saying.
you can look at the file. So you're coming back for jury trial on February 6th.
That's fine, yes, ma'am.
All right, thank you.
Thank you.
Thank you, Judge. What, I'm sorry.
How much time are y'all asking for voir dire?
Well, I think the state has an issue they don't want to talk to you about. So I don't think they want to ask for any time for voir dire.
Oh, no, this is going.
Well, I think they've got a legitimate argument. And I hate to say that, but I think it's a fair argument.
Judge, so, and I guess we were gonna have this hearing closer whenever we were about to go on this. So we subpoenaed 2 witnesses in this case yesterday. We have a jail call last night from the defendant telling these witnesses not to appear.
All right, that sounds like forfeiture by wrongdoing. So the confrontation clause doesn't apply. So what's the issue?
So that was just something that we were just gonna file a motion, Judge. I just hadn't had the time to work.
Oh,
on it,
okay.
Just because it was pretty short notice. And we had just uploaded the jail call just because it happened
Okay.
last night.
All
So
right.
I mean, this is new information to me. And this changes my way of doing the case. And I am not ready based on that information.
All right, we're going forward. If somebody makes a jail call allegedly last night, this wasn't a jail call that has been sitting around forever. If it's a jail call that was made last night, state wouldn't know about it until they looked at it.
And I wouldn't know about it until this morning.
So you all are on notice. He's alleged to have made a phone call. You have it. Have you turned it over to the defense?
My understanding is that our paralegal uploaded it in the case or either
no.
this morning.
Just have them give it to him now. Let him listen to it. Let his client listen to it. This case is going to trial. He's been in jail and this is 5 settings, so it's going.
Judge, the only other thing, so we did get discovery, there was a co-defendant in this case. The discovery mainly pertains to the co-defendant. That's what I've been uploading this morning as well, but we weren't gonna use any of the co-defendant items.
This is going to trial today.
So let me just be clear. I'll need to make a record. I believe the state of the law is I'm entitled to time to prepare for a trial. I believe that's under the due process costs and due course of law.
Mhm.
I have not had time to do that. It will adversely affect my client. I understand you have the absolute right as a trial judge to call my case. I cannot keep you from doing it.
Mhm.
I don't prefer to do things twice.
Yeah.
So that's why I'm
This-
raising the issue. with
I
you.
understand what issue you're raising. This is going to trial. If he made a phone call allegedly
Well, I don't know.
recently, well, we're gonna find out. They're gonna give you the phone call. He'll be able to listen to the phone call. But if he made a phone call last night and it's something new that they didn't know about beforehand and they're just getting it, it's going. So
That's an interesting interpretation of the law.
I know, I appreciate the interesting interpretation, but that's what happens when clients make phone calls from the jail and think that the phone calls are not recorded. When it clearly says, when somebody's making a phone call, this phone call is being recorded. And then the person on the receiving end of the
Judge,
phone call.
I understand
it
the
says
argument. I'm simply telling you as a litigator
Mhm.
that it changes the trial strategy. I believe it does affect his due process rights. And I will want to make that
Well,
absolutely, as they put it, there is no other kind of clear but crystal on the record.
oh,
And then you may overrule that.
Yeah.
I may then cite the case law that tells you you're wrong. You may ignore that and then.
Oh, let me just tell you what's gonna end up happening. I'm not hearing any motions for continuance unless a motion for continuance is filed and filed properly. And number two,
Well, now,
once that,
how would I do it in writing when I just found out about it? All right, so I will go back to the office and I will prepare that motion for continuance and I will
and
do
then
that.
I will hear it. And if that, I'm telling everybody, if that motion for continuance is based upon a phone call that he made last night, this trial is going. Are y'all ready on Estrada? Okay, I'll hear it. Court is calling 2022 CR 11013, State of Texas versus Stephen Anthony Estrada. Can I have parties announced for the record for the state? Defense?
Eddie Bravanek for the defense.
All right, this is scheduled for jury trial today. Defense, you're asking for a continuance?
I am. Your Honor, as you might have noted, starting about 2 weeks ago, I came by the court, sent the court emails, sent the prosecutor emails asking which case we were going to be trying. Reason for that is I wanted to be prepared for today. As I've told the court before, there's no on time, there's either ahead of time or behind time. This particular case, when I say it's an identification case, what I mean is that there's no question that Mr. Estrada's co-defendant is the person in the video. Everyone can tell that. The people that are identifying Mr. Estrada as being a co-defendant, because there's a mask worn, are two people. In this particular case, and the reason that on 13 they're trying to go forward, there's a clerk, I believe, that says they recognize his eyes. Pretty weak identification, but then there's a stronger identification. The stronger identification is, and I'm sorry, I don't know if it's common law wife, girlfriend, I'm unclear in the status, but significant other. I know you don't like the word baby mama, and I don't think it's the baby mama, so I'm not going to say that.
You mean the mother of his child?
Correct, yes. And I've heard you say that before, and I agree with that. I think it's disrespectful too. So when I say that this case is triable, it's triable on an identity theory. Because of that, our defensive, and I hate giving a defensive strategy, but I have to explain why I need a continuance. Our defensive strategy essentially is that it's not Mr. Estrada. That if his girlfriend comes in and says it's not him or a significant other, whatever it is, we have a fairly weak identification. There's no fingerprints, there's no other information. So the defensive theory is that it's his co-defendant's friend, brother, brother-in-law, guy he met somewhere. In other words, this is completely a blame the co-defendant. I don't so much mind saying this is fairly obvious. So I prepared for trial. I have in my pocket a thumb drive with all the information that I have completely reviewed to be prepared to go in front of you today. So two things have happened. The first thing you've already heard about it and I'll take last. But the second one is I'm now told that there's some discovery there's being uploaded today. I prepare ahead of time. I am sure that for the state, this discovery is not important. It doesn't go to their theory of the case. Of course, it goes to Mr. Estrada's right to have an effective defense. I do prepare. I want to look at the discovery. I don't know what it is. And I'm not asking for an inordinate amount of time. You bring me back 2, 3, 4 weeks, I'll be ready. Well, I see you shake your head no.
No, not 2, 3, 4 weeks.
Oh, okay.
Mhm.
But what I'm telling you is that I may be, and if you say next week, that's fine too. It isn't a question. I want to do the right thing the right way. I want to look at the discovery and judge if it doesn't make a difference. Of course, I'll be ready. If it's earth shattering, it'd be different. Now, there's some other tangential issues that you've already indicated in my motion that are not a proper ground. Fair enough. We can have that.
What would that be?
Well, there's a audio tape where some witnesses say to Mr. Estrada that they came by and served us on a murder. This is an agate robbery case. And they say, it's not the case you were thinking about. And he says, don't show up on that murder. Now, I think there's a good question whether or not that's wrongful, telling someone not to show up for an different case. That's an issue that I think in the next week, I'll be better prepared for. The next 2 weeks or whatever you tell me. And I'll await your ruling on that. I want to be prepared for that, and I will be prepared for that as well. But the reason I'm asking for time to review the discovery they've uploaded is, I know it's not important to them, but I think that a week or whatever you give me is a proper amount of time for us to look at it and me to tell you, Judge, I'm ready now or not. Absent the two issues, one of which you said is important, but I want to preserve the record. The other that I believe is important, I would be ready today. And I tell you truthfully, as an officer of the court, I've been working for the last 2 weeks. You've seen me in the court. I've asked the court in open court what case was going to be tried. I wanted to be ready today. I respect you, and I want to be ready next week, or if you call me back on Friday, whatever you do. I'm just saying, I think it's not allowing me to be effective for Mr. Estrada to ask me to look at discovery last minute that very well may change our theory of the case. Now, do I blame the state? I don't know enough to blame them, but it's a situation we're in, and that's why I'm asking for the limited amount of time that the court would give me.
Judge, I'll address the forfeiture bar I'm doing first. So Judge, they do talk about a murder case. My understanding is that our investigator did slip of the tongue because there was another murder case on the docket that he did mention murder. But in the phone call, which I don't believe defense counsel had the full opportunity to listen to because they walked away to go talk to their client. Sorry, Diana, that he mentions, regardless, I'm gonna get 25, don't show up. If you guys show up, they can prove my case. So they know that it's in regards to the cases that we're alleging against him. And he repeatedly says, please don't show up. He talks about the consequences of if they do show up and present testimony in this case, and they aren't here. They were served yesterday and were given notice to be here. In regards to the second issue, I did tell Mr. Brobenick that this was information related to the co-defense's cases in the fact that it was evidence specifically linking the co-defendant. I don't believe Mr. Estrada gets brought up in these other cases. I did see that he has a hard drive. I can upload that right now. And it's.
And so you're saying this co-defendant is evidence, the co-defendant's information that you're uploading is evidence that links Mr. Estrada to this case?
No, it links the co-defendant to the case. I don't believe Mr. Estrada is really linked through that evidence. The only evidence that we intended to show was the evidence that's already been uploaded as of today. Again, not including the stuff that I've been uploading right now, but previously. This was more of we checked, we wanted to make sure that we had everything in this case because of the co-defendant and because of the length of investigation. And so that's why we took the time to go and see if there was anything else. I think if Mr. Brobenick takes a look at that other information, there are several other cases that are looked at with the co-defendant in mind, but specifically the one that we're looking at, I can point out and say this evidence was already uploaded.
All right. So you're saying the evidence was already uploaded?
Yes, ma'am. There was significant evidence that was uploaded in this case and the other cases that Mr. Brobenick was already assigned.
All right. And the evidence that was uploaded that you say is already uploaded and you're saying significant, what do you mean by significant?
So it was just all the cases had their own e-discovery links. And so it's just each case, it's just more and more evidence for whichever specific case. But when linked together, the evidence that was previously uploaded, that's our case. You know, we're not going into the new stuff. I'm not going to present any of the evidence that was uploaded later.
So the evidence that you're saying was uploaded, has he already had access to it?
Yes, ma'am.
I don't know if I have or not. What I do know is that I am now being placed in a position where I haven't looked at what they're saying. It isn't whether they're going to present it, it's whether it's material to our defense. And I don't know, Judge, but what I do know is that I prepared by uploading each and everything in the case to this drive. And when there's additional information, I'm very concerned about going forward. It's the whole reason that we signed those discovery acknowledgements, which I cannot sign today.
But what he's saying is that it's already been uploaded and it wasn't just uploaded today, that you already have it.
Well, everything that is on this drive is what has been uploaded in this case, and I am on notice that we are trying today. I believe that evidence might be to another case, might be somewhere else, but I asked them, and I've been in open court and said it, I want every piece of information on this case. So if they're intending on bringing information from other cases, that was the reason that I went here today and said, what case are we trying? And I want to be prepared on it. On the the forfeiture thing, I actually pulled the number of subpoenas that have been done today. I went to the district clerks and there's only one subpoena requested on file on this case. I have a copy for the court. It's on Emily Rose Fritz, which is none of these individuals, and there's a return on her. So if there has been a subpoena done, I wasn't on notice of it. Of course, what I would have done is I would have discussed with Mr. Estrada, you can't mess with the witnesses, but I can only prepare him for what is in the records. In other words, there is no record of these people either being a subpoena being requested or issued.
So is your argument that if there are witnesses in a case unless they're subpoenaed, a defendant can tell a witness, don't show up?
Well, if a person has not been subpoenaed, the law allows you to tell them you don't have to show up.
No, not, you don't have to show up, but tell them not to show up. That's what the allegation is, that he told a witness not to show up, not that you don't have to show up. I've been a defense attorney and I know that people have told people, hey, you haven't been subpoenaed, you can show up or not show up. If you've been subpoenaed and you don't show up, one or two things are going to happen. Either the state is going to be like, well, whatever, they didn't show up, or either they're going to want to do an attachment.
So I am returning to what I know to be the law. And the law is that we are entitled to two things. Number one, all the discovery on a case that we've.
I'm talking about the asset,
Yeah.
the forfeiture.
So the forfeiture by wrongdoing,
Mhm.
I do not know whether, because and I have a case here that the standard is that it has to be wrongful, right? And so the question is it wrongful? Well,
Well, the question is it wrongful to tell somebody that they don't have to, that they don't show up to court? Is that wrongful to tell somebody, do not show up to court? If you show up to court, then I'm looking at 25 years. Is that wrong to do?
I believe that is the question. If that is in fact what it said, which of course is the real problem we have here. So what I don't like to do is I don't like to be at the last minute. They're saying it's in some other discovery. I don't know that.
No. I want to talk about this forfeiture by wrongdoing. That's what I want to talk about.
Yes, ma'am.
So let's figure that out. And then we'll come back to this discovery issue.
Okay.
So that's my question. So basically, and I don't know if this is your argument or not. So are you saying that if there's somebody in custody or not in custody on bond? Well, no, let's say they're in custody. That you get out of a trial, all they have to do is, if your trial is on, let's say hypothetically, February 6th, you can call somebody on February 5th and tell them not to show. And then the defense attorney can say, excuse me, I need more time. I'm just learning about this. And then let's say hypothetically, that person gets a continuance and their continuance is, let's say it's for March 12th or whatever. I'm just doing a date. And so that defendant knows their court date, their trial is set for March 12th. So they say, you know what? Let me make a phone call. And they make a phone call on March 11th, telling somebody not to show up for court, because if you show up for court, things are not going to go well for me. And then the defense attorney can come in and say, hey, I just learned about this last night. So are we going to do a situation, hypothetically, where defendants are allowed to call people the night before their trial, tell them not to show up for trial, and then everybody gets a continuance because I'm just learning that they told somebody not to show up for trial? And these are just questions I have, Mr. Estrada, and these are hypothetical questions. I'm not saying you did that. I don't know. No evidence has been presented of me, but I'm just trying to figure out everybody's legal thoughts on certain situations.
Judge, I started out a long time ago thinking I knew everything about the law.
Mhm.
I have been dispossessed about that idea.
Oh, me too.
The answer is I don't know.
Mhm.
And when I say I don't know, I'm being straightforward and honest with you. I do not know the status of the law. I do not know the status of the subpoenas. I don't know this issue. And this issue popped up at the last moment. And it did pop up at the last moment.
Well, Mr. Brabenec, not to interrupt, but I will tell you, I know the law on that unless it's changed. You know why I know the law on that? Because when I was a prosecutor, and Ms. Ferguson will tell you, on family violence cases, you would think you have a witness, they've been subpoenaed, then all of a sudden they don't show up. You check jail calls, and the night before, whoever the defendant is has called that person and said, do not show up to court. If you don't show up to court, they're going to have to dismiss the case. And you know what I would do? I would play the DVD in court and say, here's your motion. I'm doing an affidavit. I'm doing a forfeiture.
The law
by
didn't
wrongdoing.
change, in fact, since you've been a prosecutor, because I know you've been a judge at least 4 years, right?
Yeah, more than that. But
Okay.
I always try to keep up to date on law. So
Well,
I reviewed it.
so your specific hypothetical was about when you were a prosecutor and you knew the knowledge was from back.
Oh, but here's the thing. I'm telling you that because I have background and forfeiture by wrongdoing, and I always keep up on forfeiture by wrongdoing. And the reason why I do that is because I'm anticipating that usually that happens in family violence cases. So I always check the law every now and then. And then, hey, who knows? Maybe something's changed since yesterday. If it has, I'm willing to be presented with that and keep an open mind on it. I'm always for following the law.
Well, so it has changed since you were
Mhm.
prosecutor, which is where you let me know, and it changed in 2021.
Mhm.
I can't tell you in this specific fact because I've done not a briefing. But you had already indicated to me off the record that you were not going to grant a continuance on this particular
No,
ground.
not on, not because you've got new information that your client allegedly called someone from the jail last night on the 5th. At least that's what's in your motion too. On the 5th, I believe, asking somebody not to appear for trial.
Well, Judge, as you know, when I wrote this, I hadn't listened to the audio tape yet.
Okay.
So it's very difficult for me to make a good legal argument when I have yet to look over the things or read the things, which really brings, since you had already told me you weren't going to grant a continuance on the thing that you are now indicating you're not going to the grounds that you should grant a continuance, which is that I don't know, they're telling me there's new discovery that they don't believe is material. I'm telling the court I don't know. I'm also telling the court I prepared. I'm telling the court I downloaded everything. I'm telling the court that now with this new information under Michael Morton and under the Texas Supreme Court cases, I believe I'm entitled to time to review it. And I'm not asking, I've been a trial lawyer 24 years, which I believe is a little less than you, but I'm not asking for a lot of time. I believe in a week I could be here standing and say, Judge, I'm ready, they were right. Or Judge, we've got an issue. And if there's an issue, I'll come by on Wednesday, Thursday, Friday, as soon as I can. In other words, I'm not going to let it sit out there. But at this point in my career, I am unwilling to take the other side telling me that something is not material to my client's case and is not important.
You're coming back tomorrow for trial. That's the time you have. So whatever he needs to see, he needs to see it.
Yes, Judge.
If he needs to listen to that video, the audio from the jail, he needs to listen to the audio from the jail about your request for forfeiture by wrongdoing. Y'all are here, listen to it. But you're coming back to trial for tomorrow.
The next day, Stephen Anthony Estrada stood before Judge Boyd in Bexar County. Instead of moving forward with a jury trial, he entered a plea. Judge Boyd dropped a harsh sentence: 4 separate 20-year prison terms for aggravated robbery, all handed down on the same day. A week later, Estrada faced another courtroom in Hays County. Once again, the gavel came down hard: another 20-year term for aggravated robbery. The sentencing hearings were not broadcast, but the jail records confirmed the outcome. 20 and 20, and another 20, followed by 20 more in a neighboring county. Altogether, those punishments mean Estrada is locked into the Texas prison system with a projected release date of September 28, 2043. Multiple convictions across 2 counties, sealed by some of the toughest sentences a judge can impose, ensure Estrada's future is written behind prison walls.